Hi, everybody. Jason Carpenter, your broker, coming to you from my office via YouTube video. And today we are going to kick off what I call Contract Ninjas. And Contract Ninjas is a term that I'm coming up with for a higher level of understanding of our documents that we use in our real estate practice every day that will teach you to better present, create better strategy around your real estate transactions, become a better negotiator, and ultimately a contract ninja, if you will, when it comes to performing your real estate transactions. So we're going to jump into this. Our videos are going to try and be around 5 minutes. I just took our first take and I ended up at 10. So I'm going to watch the clock on this one and try and get through it rather quickly. We are going to have some days where we cover one or maybe multiple documents, and you can see them on screen as I go through them here. Other days, we may just cover a single paragraph in a purchase agreement and go into more depth and what that means in your real estate practice. So we're going to kick this off with a disclosure regarding real estate agency relationships. Now, we learned in first week of training, probably in pre-license class, that this is the first document we have a potential buyer or seller of real estate sign. We should be getting this sign when we meet with them before they reveal any confidential information to you about their real estate needs or wants or desire to sell or buy. Now, in reality, I will tell you that a lot of people are averse to signing things. It's good to be able to explain things to them and what they're signing. So basically, the first part of this tells you what the state says you have to do from a fiduciary responsibility angle. Look, Mr. and Mrs. Buyer of real estate, I have to exercise reasonable care in presenting and representing you and carrying out the responsibilities of the agency relationship. I have to perform to the terms of the service provision agreement, meaning either my buyer agency or my listing agreement. I need to have loyalty to the interest of the client. I have to put their needs in front of my own when it comes to financial matters. I have to comply with all laws and rules and regulations. I have to refer to the client to licensed professionals. I'm not an attorney, I'm not an accountant, and I'm not an inspector. I'm going to refer you to those people that do those things. I have to account for money that you give me in a timely manner. Again, think about those earnest deposits when you're getting them in and getting them in a timely manner. We have state laws on that. So this goes hand in hand with that. And keep confidential all information obtained within the course of the agency relationship unless disclosed with the client's permission or as provided by law, including the duty not to disclose confidential information to any licensee who is not an agent of the client. So an interesting conversation with another agent on a deal. She told me right away what the client's bottom line was. I said, thank you. She probably shouldn't have done that. So now, a real estate broker or real estate salesperson acting pursuant to service provision agreement shall provide the following services to his or her client. So you have duties and services in this first paragraph here. And so when we talk about services, we're talking about marketing of the property agreed to in the listing contract, delivery and presentation of offers in a timely manner, assistance in developing communicating, negotiating, and presenting offers and counteroffers and related documents or notices until a purchase or lease agreement is executed by all parties. So again, you're writing offers. After execution of a purchase agreement by all parties, assistance as necessary to complete the transaction under the terms specified in the purchase agreement. So contract to close, that's a class here. Take it if you don't understand it. Get back into it if you're not in full understanding of it, and make sure you know how to close a contract. For a broker or associate broker who is involved at the closing of the sale, we are furnishing a closing statement. So again, a full accounting of all monies for both parties. So that's up to the title company to develop that. It's up to the broker to sign off on it. So it's not your responsibility, but it's your responsibility to make sure it gets there. So now, we can represent a seller, we can represent a buyer, we can represent somebody as a dual agent as long as it's fully disclosed, and we can also act as a transaction coordinator, which we really try to discourage here at Keller Williams. So with the seller's agent, obviously someone with a house or property to sell, you can authorize a seller's agent to work with subagents, buyer's agents, or transaction coordinators. A subagent of the seller is one who has agreed to work with the listing agent and who, like the listing agent, acts solely on behalf of the seller, i.e., somebody without a buyer agency contract. Could be somebody in our company, could be somebody somewhere else. We don't like to pay those people. We'll get into that more later. Now, buyer's agents, you have a buyer agency contract in place. You're representing the buyer, and individual services may be waived by the buyer through execution of a limited service agreement. I don't know how you represent a buyer on a limited service basis. I don't like the language in this, but it exists and we have to deal with it. So now we really try to discourage dual agency and transaction coordination for one of two reasons here. One is dual agency, it's hard to represent both parties. So if you have somebody come into an open house or call on a sign and they want to buy your listing, just sell it to them, disclose that you're acting as a seller's agent, have them write the offer, and don't put them under buyer agency contract. It avoids dual agency, and it's the cleanest way for us to have single representation of our clients. Transaction coordination, that might be your uncle saying, hey, I'm selling your sister-in-law this piece of property. Can you do the paperwork for a fee? We really try to discourage that. We want some representation in a contract form, either on the listing or the buying side on that. So now, explaining designated agency to the general public is always kind of tricky. You're going to want to say, hey, look, we are a designated agency company at Keller Williams. What that means is that it has to be my listing as the listing agent and my buyer under buyer agency contract to constitute dual agency. And I use Kevin Allen's name all the time. It's just the one that pops into my head. Kevin Allen has a listing. It's my buyer under buyer agency contract. It does not constitute dual agency at the agent level, and therefore each party can be represented by an agent under one roof here. So, simple way to explain it: you mark who you're representing, either the seller or the buyer, and whether or not you're acting as a designated agent. So you should be able to get through this in probably a couple minutes of explaining what this document says, why your people are signing it, and why you need it signed sooner than later. Again, state law says that you should have this signed right away when you meet with somebody, even before a buyer agency contract. You mark here that you're acting as a designated agent. And you mark here that they don't have an agency relationship with any other real estate licensee. Let's hope not. And you have them sign as a potential buyer and seller. You're signing it as the licensee. So we keep it on file in case a judge calls up and says, hey, I want to see you in my courtroom, and I'd like to know whether or not you explain to your client how you work on their behalf. You've got a form that says, yes, Your Honor, I did. And we have this form that says that. So important to keep that in your dot loop or in command, however your transaction management and document management is being used. So again, disclosure regarding real estate agency relationship, a simple form. It's not a contract, and you should get it signed when meeting with a client for the first time. As always, any questions, feel free to reach out. And if you want further information on this, I'm happy to talk to you about it one-on-one. Thanks, and have a good day.